Welcome, everyone. My name is Sarah Ray from the Bloomfield Public Library. Thank you for joining us tonight. We're really excited to have this estate planning program as one of our legal literacy efforts in partnership with Doll's House Foundation. So I'm going to pass the mic over to Khalid. Go for it.
Good evening, everybody. I hope you can see me because I can't see myself. Hopefully my glasses are not reflecting in this camera. Anyway, I want to thank you all for being here tonight. Our theme for our awards year, we are 11 years strong, picking themes that reverberate with the community. And this year is financial literacy. Give me liberty or give me debt. Tonight's class is about planning for the thing that we always delay, but we know causes so much strife and drama in families when not addressed. I am so blessed to have Kyle Edmonds, Esquire, attorney at law, here to break down some of the fundamentals of estate planning. And we're going to be continuing for 3 more months with the theme of financial literacy, various events, posts, and resources. Check the chat for a link. We'll have a link to a video recording of this event and some other events, as well as a financial cheat sheet in our link tree. Look for that in the chat. And I'm going to pass it to our magnanimous leader and founder, Ms. Meredith Johnson.
Well, good evening, good people. Is it hot enough for you? I hope that you're cool and you're going to be hydrated, your mind focused to experience this educational forum. As Khalid said, we got a couple of Ks on the line. First, want to give acknowledgement to all of the Dow House committee members and volunteers that are on the line right now. We have Cheryl Mitchell, and we have one of our board of directors, Marcia Lawrence Edmonds. Is there a relationship to Kyle S. Edmonds? I'll let you all figure it out. As Khalid mentioned, Attorney Kyle Edmonds is an attorney extraordinaire, but just want to give a little bit of background. He was raised in Harlem, born, bred, raised, and loved. The son of a civil servant and an entrepreneur who both believed in hard work, discipline, self-determination, and supporting the greater Harlem community. And if anybody knows Attorney Edmond, he continues that legacy on a daily basis with his wife and children. And brother, these values instilled in Kyle and his brother Kendall at a very young age. And he watched his father employ family and friends at the Edmonds Barbecue Restaurant. Kyle's mother, a very active member of her church community, has taught him the value of dedication, family saving, owning life insurance, investing, the need to build wealth and create a legacy. I speak about her in the present tense because her spirit is on this call. Because with that legacy, it entrusted in her son the thought process of plan and be prepared. Kyle attended St. Aloysius Elementary School in Harlem, then Cardinal Hills High School in the South Bronx. Kyle went on to Boston College, receiving his Bachelor's of Arts degree in political science. Excuse me, call it the heat. The heat has my tongue. Subsequently, Kyle received his Juris Doctorate from the University of Baltimore School of Law. Attorney Edmonds is licensed to practice law in the state of New York since 2001. In the Southern and Eastern District Federal Courts of New York since 2006. Attorney Edmonds, I did not know that. Wow, outstanding. Kyle worked at a law firm in the Wall Street area for over 10 years, sharpening his skills as an attorney, and became an excellent and successful litigator while also bolstering his experience in estate planning. And that is what we're going to talk about today. So without further ado, thank you, Attorney Edmonds, for first of all, offering your charitable knowledge. Also, thank you for supporting the foundation, Dow's House Foundation, which is an organization simply geared to charitable giving and charitable knowledge. Thank you so much. So Kyle, we'll pass it on to you.
Thank you, Meredith, and greetings to everybody. Thanks for coming through. Really appreciate it. Right off top, I just want to say, if you're comfortable, I invite you to turn your camera on. I like to see who I'm speaking to, and it helps with engagement. If you're not cool with that, no problem. We'll make this work nonetheless. Legal disclaimer. So I'm an attorney admitted to practice law in the state of New York. This is a seminar designed for general and educational purposes and should not be considered legal advice. There is no attorney-client relationship formed with merely attending the seminar. For guidance on your personal situation, please contact me if you're in New York. Otherwise, I would say that you need to speak to a lawyer in the jurisdiction where you reside. All right. The purpose for me being on this, first and foremost, is to acknowledge Josephine Dahl Johnson, for whom Dawes House was inspired by and named after. I support the foundation and its mission, especially as it relates to financial literacy. I never had the pleasure to meet her, but I'm well acquainted with her daughter, Meredith. And I know just based on that relationship, she had to be one heck of a lady. I also want to support and bring value to the Bloomfield Public Library and all of you who came to support and obtain a little knowledge. All right, let's begin. What up, Irv? My mom and dad are deceased, and neither of their deaths went as smoothly as it could have been. So my mission is to try and help those not experience those negative aspects of not having matters in affairs in order on top of dealing with the grief. If you're on this call and you're of a certain age, I'm sure you can relate. I want to let you in on a not so big secret. So at some point in time, I'm pretty sure that everybody on the Zoom is going to die. But too many of us act as if it's a possibility and not a certainty. You can minimize the stress and challenges of death and disability through estate planning. What's estate planning? It's a plan simply about your estate when you die or become incapacitated. Your estate is broken up into two parts. It's you, your person, and then it's your assets, as well as your debts. An estate plan generally addresses 4 areas. 1, it's a plan that helps you control your property while you are alive and well. 2, it's a plan that provides for you and consequently your loved ones if you become incapacitated, disabled, or die. 3, it's a plan that gives what you have to whom you want, the way you want, when you want. Lastly, it's a plan that helps minimize the impact of fees, court costs, and taxes. Some of you may be really into taking notes, and I applaud you. If you're not really into that, don't worry so much. we should be producing something that you'll be able to take away from what we're discussing tonight. All right. What's the first step? First step is to have a plan. So, you know, I've been on my own since 2014, and I have a lot of clients. I have a colleague who I work very closely with, my LB, Brother Jason Taylor. What up, Jace? And at first, when I entertained a potential client, they would come to see me. They would say, I need this. And I would try and facilitate this. But we get 2/3 down the road and realize that this wasn't covering or achieving the goal that they saw. So we quickly changed up, and instead of listening to someone tell me that they may need a particular tool or document, we back up and ask, what is the goal? What is the plan? The most important thing that I've mentioned up until this point is to have a plan, right? So what do you need to do if, in fact, you're going to die, right? Who do you want to be in charge? If you become mentally or physically disabled, who do you want to have handling your affairs? Once you get an idea of who you want in that position, then you can begin to address how best to effectuate the plan. What are the tools that help you achieve the plan? The tools that help you effectuate the plan make up the basic components of an estate plan. What are they? These are the docs that most people are familiar with: a will, last will and testament, a trust, a power of attorney, a healthcare proxy, a living will, and for those in New York, disposition of remains. By way of hands, or if you want to put in the chat, how many of us have an estate plan? Okay. All right. The overwhelming majority of us normally do not. And that's not just us. When I say us, I mean people in general. Even folks over 50, I think the statistic is only about 60% have an estate plan or some form thereof. Hopefully after this, you know, we'll figure out what's the best way to make a plan for your estate. Because the thing is, it's not just a matter of it being for you, it's really for those people who you love. If you've lived any kind of life, you've probably experienced what I experienced personally, as well as with looking at a lot of clients' experience, which is having situations where there's nothing really planned out. The thing is, this information and this subject is so serious that the government won't allow a plan to not stand. In other words, they give you a default plan, right? Because it's too much of a public risk to be completely out of order. And so if you don't take the steps to initiate a plan, they give you a plan. They give you a plan that you may be okay with, which is why you need to know what the plan is, and you may not. Again, knowing what it is can help you to figure out the route to take. All right, so I've given you the basic tools. I'm going to give you a simple summary of how these tools work, why you need them, and what happens if you don't have them. Okay, let's start with a will, last will and testament. Most people have heard of that. What is it? It's usually a written document that disposes of your probate assets at the time of your death. Now, I said probate assets. What does that mean? That means assets that the decedent, that's the person who dies, they own in their name alone. So that's different than if you own property that's connected to someone else, like a joint owner, joint beneficiary, a joint owner or a beneficiary on, let's say, like a bank account or a securities account. Anything that's connected with someone else, a will is generally not applicable to. It is only applicable to those things that you own in your own name. That's important to know. How does it work? Well, a will only takes effect upon your death. At no point in time before then does a will come into play. You can, if you have a will, you can change the will, you can get rid of the will. It has no real legal effect until and unless you die. Once you die, then the will has to be submitted to probate. Probate court, some places like New York call it surrogates court. It has to be submitted so that the will can be authenticated as valid, right? Because anybody could create anything, but you had to take the proper steps in making sure that it was created right before it gains the legal effect and impact. And a judge is the one who views this process and either gives you the stamp of approval or not. Now, if it's not stamped correctly, it's deemed invalid. And the will that you thought you had doesn't exist, and you're deemed to have died intestate. Fancy word, just means without a will. If the court deems the will valid, it's admitted for probate, and then the court instructs the executor, that's the person that you name in the will when you die, to take care of and carry out the wishes of the terms of the will. So everything you laid out that you want to have done, people who you want to receive things, you essentially have to appoint a point person to do those things. Once that's done, then the court will go through the process of making sure the funeral expenses, administration costs, and debts, including your taxes, are all reconciled before distributing out to any beneficiaries. So an important point here is that you have to make sure that the will is valid and accurate before it takes effect. And this is a good place and space to speak about DIY, do-it-yourself wills versus a competent attorney. Now, I'm biased. I'll admit that right off top. But while we may be trending in that direction with AI and the like, there's a distinction between doing a will online as opposed to going to someone who knows what they're doing. Again, you don't really know for sure that what you're doing is accurate until it's too late, because the time to submit it is the time where they check it. They don't give you a test or a scenario where you pre-check it. Now, having said that, as I mentioned, the trend is going in that direction. And currently what I would say is there are people who use these DIY software. Is very popular. I would say if you considering doing that, to do your homework and or to do it if you have a simple estate, something not too technical, not too difficult to figure out. The way they're designed is for simple estates. It's not designed for a whole lot of back and forth. And they'll tell you that they're not a law firm. So it's done with a whole bunch of algorithms for real simple estates. And if there's issues that require a lot of back and forth explanation, then they will direct you to someone like me to help them out. All right, why do people need a will? Well, first of all, is it mandatory that you have a will? No, it's not. I already told you that there are a lot of people who don't have one to begin with. So it's not mandatory to have one. But the reasons why you should have one, especially as it relates to minor children, if you have children under, a certain age, the age of majority in your state, you can name a guardian for the child and or their property in your will. If you didn't have that, that's a potential issue that you may have to deal with. If you're a single parent, or if something happened to the other parent, the child would then be faced with having to go through a guardianship procedure. Another good reason to have a will is, don't know how many you know, but you can actually disinherit your children. There's no law mandating that you give your children anything. However, if you died intestate, that's not the case. So that may or may not be an issue, but it's something relative and good to know. I should say, if you're married, that does not continue on with your spouse. You cannot disinherit your spouse. So any of you who are thinking that, get that out of your mind. The spouse has what's called a right of election. And even if you try to write them out, they can elect against your will and get what's coming to them. In New York, I believe it's $50,000, and the greater of $50,000 or 1/3 of the estate. So, all right. Again, what happens if you don't have a will? Okay, so this is what I alluded to earlier. The state deems it too important. So they give you a default plan. So whether or not you did any estate planning to this point, just trust in and know that you already have a plan. And that plan is, if you die in New York, and this is kind of the case in most states, it varies little, but in New York, the intestacy statutes determine who and how your estate will be distributed. For instance, let's say you die with $100,000 in your assets and you're married with 2 kids. So right off top, New York State gives the spouse $50K. So 50,000 of that 100,000 is going to your spouse. So there's 50,000 left. Out of the 50,000 that's left, an additional 25, which is half, is going to the spouse. So 75 out of the 100,000 is going to the spouse. That leaves 25 left. You have 2 kids. Whatever is left is split equally between the kids. So they would each get 12,500. Let's say you were married and you had no children. Then everything goes to your spouse. Let's say you were not married, but you had 2 kids. Then everything goes to your kids. Well, what if you're married, you're not married and you have no kids? And in that case, whatever you own would then go up to your parents. If your parents are deceased, then it comes down to your siblings. If your siblings are deceased, then it goes out to your cousins. If your cousins are deceased, virtually no family members, then whatever you own goes to the state. So you may like some of those scenarios, you may not. you have the choice to make a decision on how your assets are to be distributed. And all except your spouse, can you give or not give? When you die without a will, I see many of us on here who are part of college or fraternity or sorority or your church or any of those organizations that you love, they would get nothing. If you have a really good friend, let's say, who has been taking care of you when you were sick, that friend would get nothing. For those people who are ardent supporters of Doll's House wouldn't get a penny. So having a will would allow you to make a donation to that particular entity, person, that's not related to you. And so if that's something of importance, then I would say considering getting a will is very important. Again, if you don't have one though, it increases the likelihood of disorder, conflicts, bitterness, and after death disputes between your children and other family members. Good example is, there's a big controversy on who was better, Brother Michael Jackson or Brother Prince. Michael Jackson, now each of these men died with over $200 million in assets. However, Michael Jackson, he died with a fairly simple but effective estate plan. He had a trust and a pour over well. He designated his mom to be the guardian for his children. And for the most part, there was some bumps in the road, but for the most part, his estate went according to plan. Prince, on the other hand, died intestate, without a will. Again, over 200 million in assets. And when I was putting together my documents before, so there were a lot of issues with Prince, in terms of just who his family was, trying to identify siblings who were coming out of the woodwork, from half brothers, half sisters, all of which took court time and resources. As a matter of fact, over $46 million was paid out to lawyers, accountants, and consultants regarding Prince in making these determinations. Just as important, $31 million was taken out in taxes. Now, if you're doing the math, at least at that particular time, you're talking about almost half of his 200 million going to expenses I'm sure Prince did not anticipate or want. But this is what happens when you fail to do what you need to do to position your estate and your family. It's also good that if you have a will, that you make sure it's not outdated. Brother John Singleton, right? He was a famous filmmaker, Boys in the Hood, Ice Cube. He had a will, but it was outdated. It was 26 years old. And at the time when he had it created, he included his daughter. The problem is by the time he died, he had 7 children. And he failed to have the proper necessary language in the will to include the additional 6 kids. And so you're left with a situation with the eldest daughter receiving everything and the others nothing, left up to her and her good graces to share the wealth. Good luck with that.
Uh-oh.
It's good to review your document on a regular basis if you have it, and if there are any particular life changes, you should also review it. Someone dies, a beneficiary, got sick, or child passed, predeceased. These are all instances in which you may want to amend or do a new estate plan to make sure it's in alignment with your wishes. All right. What are the drawbacks for having a will? Well, there are some, and in fact, it can be quite costly and lengthy to probate the will. So I told you you had a will, but when you die, they have to take the will to court and the judge has to okay it. Well, that whole probate process can be pretty long, depending on where you are, what type of jurisdiction you're in, and how backlogged the courts are. I mean, as a matter of fact, because of COVID and so many deaths, the court was unbelievably backlogged. And to get things done through the court has been elongated. So a process that may take anywhere from 6, 7, 8, 9 months is now being extended to 12, 18 months and longer. So, that's something to consider. Also, a will is a pretty public process. It's how we know about so many celebrities, the celebrities I just mentioned, Marilyn Monroe. Once you submit to the public process, it becomes a part of the public domain, and that information can be dispensed. So some people are not bothered by that. Some people are, and opt and want to have privacy, right? I don't want anybody knowing anything about my business. And so if that's you, then there are alternatives which you can do. Before I get to that, let me just say also there are small estates, right? And in New York, and I believe it's the same for Connecticut, if you have an estate that's, for New York, they just upped it from 30,000. But if you have an estate that's 50,000 or less, your assets, they allow you to apply for what's called a voluntary administration. And that's important because it's a much quicker, faster process. It's a smaller filing fee. I think the filing fee is only $1. And it's a lot less lengthy process to go through, which is good. If you have a smaller estate, it helps. And so that's something to be noted. Again, I think for Connecticut, it's 30,000. But again, it's still a public process. And so what if you wanted to avoid the public process? Then what you do is the public process is probate. There are what's called probate avoidance tools, right? You can opt to do, again, going back to the most important thing here is to have a plan, right? Not to get lost in the title of a will and any of these different names, but what's the plan? So a probate avoidance tool, it allows you to avoid going to court, right? It's property which 2 or more individuals hold as joint tenants with the rights of survivorship. Very important. These are also pay on death accounts, in trust for accounts, insurance policies, pension or retirement plans that have, now this is key, it has to be this, that have a designated beneficiary, except where the owner of the policy is also the beneficiary. So all what I just mentioned will pass directly to the joint owner or the beneficiary named in the contract, regardless of the language in the individual's will. So this is a good alternative. And when Marcia and I got married, it was not too long after passing the bar exam. We didn't have really many assets. And so instead of opting to pay an attorney to draft a will, I knew the plan was to place what we did have in probate avoidance tools. So we had joint accounts. If I or she passed, the survivor would then receive the other share without having to go to court. We had life insurance policies, term policies, naming each other as beneficiary, not having to go to court. So the majority of our quote unquote assets were in probate avoidance tools, didn't need to pay for a will at the time, and so we didn't. However, circumstance and things change. You know, we began to make a little more money, or she began making a little more money, got a house, we had children. And so these scenarios changed the situation so that the probate avoidance tools may not have been necessarily the best bet. And as a result, we then moved on to get a will-based plan. Another probate avoidance tool is a trust. Many of you may be familiar with a trust. What's a trust? A trust is a written legal agreement between three parties to provide for the management and disposition of assets. The three parties include the trust maker, called the grantor, settlor, trustor, the trustee, and then the beneficiary. The grantor is the person who creates the trust. The trustee is the person who manages the property, has control. The beneficiary is the person who receives the benefit of the property titled in the trust. How does it work? All right, the trust maker funds the trust by transferring ownership of certain assets to the trust, and then the trustee then manages it for the benefit of the beneficiary. A living trust is created and goes into effect during the trust maker's lifetime, sometimes referred to as an inter vivos trust. They're typically formed by the executor of the decedent. I'm sorry. Inter vivos trust is mainly when you're alive, right? There's a different type of trust that goes into effect when one dies. That's called a testamentary trust. So you can have a will and create a trust from your will. How does that work? When you die, you leave your trust as the beneficiary of your estate. And the executor is the one who becomes the trustee to administer the trust. Now, trusts usually come in two major forms. Those major forms are a living trust, which is a revocable trust, and an irrevocable trust. What's the difference? All right, with a revocable trust, the three people I mentioned to you, the trustee, the trustor, the trustee, and the beneficiary, they're all the same person. The two most common purposes for having a revocable trust. Now, remember, I told you about that will. The will is public. You have to go to court. People know your business. With a trust, a revocable trust, the main reason people use that is to avoid probate. So it's a much more private process. Let me take a step back. So in layman's terms, what a will does when you die, whatever you own in your own name, the process is to take what you own and put it in the name of the person who you want to give that asset to. So let's say, I owned a car or a piece of property, and I wanted to give that to someone in particular. Then at my death, when the will is probated and found to be valid, they will change the title from my name, Kyle Edmonds, to friend. That happens at death. I say that to explain the difference with that in a trust. The trust is the same process, but you're doing that while you're alive. So I'm taking whatever asset I own in my name and I'm transferring it out into the name of the person or trust, devoiding myself of ownership interest. So the other reason people do a revocable trust, in addition to avoiding probate, is to plan for mental disability. So if one becomes disabled, and disabled means you're incapacitated mentally, you fail to appreciate and understand the nature and consequence of doing a particular act. Oftentimes you have to seek a guardianship to be able to move forward in controlling that particular person's asset. But if you have a trust, a revocable trust, you can name a successor trustee, someone to take over to assist in the event you become incapacitated. That avoids having a court to name a conservator or a guardian to take over for that person's financial affairs when they're unable to do so. All right, so that's a revocable trust. And irrevocable trust, by the way, revocable as it sounds, which means you can create something, but you can also revoke it. You can amend it, you can change it, you can end it. So it has a level of flexibility to it. And irrevocable trust is as it sounds. Is irrevocable. You generally cannot. The trust maker can't act as trustee if he forms an irrevocable trust. So I told you with the revocable trust, all three different parties can be the same person. It could be you. You can be the grantor, you can be the trustee, you can be the beneficiary. Especially only if you're seeking to, avoid probate, you want privacy, or you want to be able to have someone take over if you become disabled. No problem. With an irrevocable trust, that's not the case. Now, the most common reason people want an irrevocable trust is to move assets out of their name, maybe for the next generation, for their use and enjoyment, which reduces the value of the trust maker's estate for estate tax purposes. So this is for people who rolling in the dough, right? In 2023, the federal estate threshold is $12.92 million. So what that means is if you have an asset worth 12.9 million or more, you are subject to a federal tax that goes up to 40%, which is a lot. So this is why you see those people who have a lot of money making maneuvers with tools like an irrevocable trust. I gave you the number for the feds. but there's also a number for the states. For 2023, New York has a 6.580 threshold. So if you have assets totaling more than that, then you're potentially on the hook for estate tax at the state level. Really, it has to exceed 5% more than the total I just gave you. A lot of the states have the same. I know for Connecticut in 2022, that number was 9.1 million. So for people who have a lot of net worth, what they do is make maneuvers to potentially avoid having to pay the government up to 40%, almost half of their money. They place their money into irrevocable trusts, divest themselves of ownership of the assets, and therefore, when they die, that money that they put in the trust is no longer associated with them. But you're still doing it in a way where you're hoping to direct and guide where that money goes, as opposed to having to outrightly give it to the government. All right, what happens if you don't have one? So with a revocable trust, if you act as all three parties, you have a revocable trust, which can change and revoke anytime, but you only receive limited protection, right? I mentioned, you can avoid probate and the disability issue, but you're still subject to you have minimal estate tax savings, and there's no special government program benefits. And if, however, you take away your ability to change the trust or name of the trustee who is unrelated to the beneficiary, you have given up a substantial control over the trust. So under these circumstances, the government concedes you've divested yourself enough power to grant the beneficiaries of the trust certain benefits. All right. In an irrevocable trust, the only time you would consider this is, again, if you want to minimize estate taxes. 2, you want to become eligible for government programs, or 3, you want to protect your assets from creditors. So I get a lot of this. There are reasons why people want irrevocable trust. Your parents, you may be considering Medicaid. This is where you would go in terms of an irrevocable trust to help with that. On the flip side, you could use a revocable trust for the areas that I mentioned as well. I just want to say, oftentimes, the trust is getting on the more convoluted and complex side of things. And a lot of people think that may not have what it takes to use a trust. And I say that's not true. I don't know how many of you are familiar with the lady Osceola McCarty. Has anybody heard of Osceola McCarty? Okay, I figure you might. And I think about your mom when I was reading this. So Osceola McCarty was a disciplined lady, frugal, and she had a plan. She was a washerwoman in Hattiesburg, Mississippi. She had a 6th grade education, but she went on to become the University of Southern Mississippi most famous benefactor. She was born in 1908, died in 1999 at the age of 91. In 1995, she established an irrevocable trust with her bank as the trustee. She left all she had and set aside 10% to her church. And each of 3 relatives, they were cousins, She never married. She gave 10% to each of them. And then she left 60% to students. Now that 60% amounted to approximately $150,000. Mind you, she was a washerwoman and she washed clothes for white folks. As a matter of fact, the lawyer who helped her with the irrevocable trust is someone who she used to wash the clothes for he and his family. She left $150,000 to in an irrevocable trust for students at the school, and she asked that it be preferably for students of color who had financial hardship. Once word got out, the business people in the town were so taken aback by what she had done, they matched her $150,000 and $300,000 went towards that aim. Now, I say that story because, one, I want to give homage to the Black woman, especially as we're here with Doll's House. But again, she didn't make much. 6th grade education, she had to drop out of school. And if she could do it, then we all can do it. All right, moving on. Durable power of attorney. What's that? Power of attorney allows you to appoint another person to make financial and legal decisions for you in the event you are incapacitated. The ability to comprehend the nature and consequence of executing and granting, revoking, amending, or modifying a power of attorney, whether due to illness, injury, or dementia. This is a real big tool. It's not as sexy as the will, or the trust, but it really is powerful. How does it work? The power may be limited in duration and scope, or last a lifetime, and generally covers many areas, including signing papers, checks, handling bank accounts, and other activities in the name of the person granting the power. The person receiving the power of attorney is called the agent, is the attorney in fact for the person given the power. That's the principal, and usually signs the document as Jane Doe, attorney in fact for John Doe. Why do you need this? What's the benefit? Well, particularly for those of us who have aging parents, aunts, uncles, friends, power of attorney can be vital to taking care of you and your family if you or they become incapacitated, and avoid the potentially costly and cumbersome process of seeking guardianship or conservatorship from a court. Among other things, it allows you to handle their finances, including taxes, bills, bank accounts, real estate sales, if they become incapacitated. How many shoppers out there? Who likes to go shopping? Yeah, I know Marcia raising her hand. Right. So the reason I ask that is, shoppers are usually ones who like to look for a good deal, right? You want to pay less than what you would ordinarily pay when getting the same item. Well, this estate planning stuff that I'm talking about is just that, right? You take the time, this is a subject that most people don't like to talk about, that most people of color don't like to talk about, and certainly most Black folks don't like to talk about. Nobody likes dealing with subject matter that's a little depressing. But here's the deal. As I mentioned to you, the state gives you a default plan. They don't care if you made a plan or not. They're giving you a plan. It's just too important. So you need to take the steps to do it. You need to take the steps to talk to your parents if you haven't done it. The blessing is, if you do it, then you're able to get a discounted rate. It's much simpler, cheaper, faster, easier if you do these things on the front end. If you don't, the back end is just the opposite. You're getting no deals. Matter of fact, the way my business works is I get much more money when people have to come to me than when they should come to me. You know, I need to get a will, I need to get a power of attorney, I need to get a trust, but don't do it for whatever the reason. But then the person dies and they may be a beneficiary, but they can't do anything unless they go to court and go through a process called administration. Now, at that point, you're at the mercy of lawyers like me and what we may charge on the back end, which I must tell you is more expensive than on the front end, right? Because now you have no choice. You have to see me or someone like me to be able to move forward in getting that house out of grandma's name or that particular asset out of your mother's name for you to be able to move forward with it. So a power of attorney is really good. And having that ahead of time allows you to be able to maneuver without having to deal with issues, including guardianship, which is a very costly, time-consuming process. It's much the same with a healthcare proxy. Another one of these not as sexy tools, but really effective. Healthcare proxy is a document that allows you to choose someone you trust to make healthcare decisions for you if you lose the ability to make decisions yourself. How does it work? The person you appoint, the proxy, will have the authority to make medical decisions for you. It allows the doctor freedom from liability if they do what the proxy requests and you later disagree with what was done. After appointing the proxy, it's extremely important to discuss your wishes with them and speak about your medical care, including resuscitation, artificial nutrition, hydration, and personal goals for quality of life. Therefore, you should provide guidance to your proxy and agent to what kind of decisions you want made under various circumstances. And the agent proxy must act in accordance with your wishes. Why do you need them? It's vital to have a healthcare proxy in place, and you should communicate clear instructions regarding your treatment. You may communicate your wishes to your medical treatment personnel if you're unable to do so. What happens if you don't have them? Well, just like the durable power of attorney, the medical directive, it avoids costs and complications you would be faced with, like guardianship, if you didn't have it. Quick story. There's a guy and a girl, they were married. The guy got into a snowmobile accident, went into a coma, couldn't really speak, didn't have a healthcare proxy in place. His mom, who loved him dearly, wanted, so he was really, really ill. They weren't sure if he was going to make it. The mom was leaning one direction and his spouse was leaning in another direction. Well, he didn't have a healthcare proxy, and the doctors were talking to the wife and the mom on what to do. They were split. So the doctor didn't really want to act because he was afraid if he went one way or the other and it didn't turn out right, he may get sued. thankfully, after a long time in the coma, he eventually came out of the coma. And there wasn't a legal issue that ensued, but that was going to be the next step. If this gentleman had a, excuse me, if the wife had a healthcare proxy in place, then this would not have been an issue. With a healthcare proxy, you designate who you want to speak on your behalf, medically speaking, which is the difference with a power of attorney. Power of attorney is dealing with finances. Healthcare proxy is strictly talking about medical. You have someone you designate if you can't speak yourself. And it's extremely important to have that. And again, if that's not in place and there's an issue, you might find yourself in smack dab in a guardianship proceeding. So healthcare proxy is very simple. Power of attorney is very simple. They can be complex, but it's good to have. In the same vein as these two is a living will. A living will is a document that specifies what type of medical treatment you would or would not want if you were unable to communicate. These treatments may include resuscitation, artificial nutrition, and hydration, and medical mechanical ventilation. So these are end-of-life decisions, right? That addresses that. The difference between a living will and a healthcare proxy, you're designating a person to speak on your behalf. The living will is a document where you're writing down, typing up preferably, what you want to happen in those situations. They're not mutually exclusive. Matter of fact, they should operate in tandem together. And you should be able to utilize them. Again, it's good to have clear communications and instruction from a written document regarding your medical treatment. What happens if you don't have it? Much like the durable power of attorney and the healthcare proxy, living will can avoid costs, complications, and the like. But if you don't have it, then you're subject to what the law of the state is. And many times that's something that's left up to the doctor to make a decision depending on where you are. You know, if you're in a hospital or a nursing home, they may give an option that goes in priority with your spouse, parent, family member, or friend. The last of these documents is a disposition of remains. And what is that? It's a formal procedure that allows you to designate an agent to carry out your burial and funeral wishes and make related decisions after death. So this is something New York State came up with not too long ago, allowing you to do this, because what happens was, you know, you would have a daughter saying, my mom wants to be cremated. And then the son comes in and says, no, mom didn't want to be cremated. She wanted to be buried. And so now the funeral director is in a bind. What do you do? So this allows you to designate an agent, particular person, doesn't have to be family, can be family, but you designate a person to speak to these particular needs at the appropriate time. In the absence of it, it's the same hierarchy. Goes to your spouse, parent, sibling, friend. It's good to have. And in this document, you also get to provide for other death-related items, such as pre-need agreements. What's a pre-need agreement? Pre-need agreement is, many of us don't plan, right? And sometimes life happens to us and death happens to us and we're not prepared. And the funeral is upon us. We may not have the resources necessary. And so then we're gonna scramble and try and figure out ways on which to pay for the funeral. Well, a pre-need agreement allows you to prepay for your funeral ahead of time. Well, why would you want to do that? Well, you get to lock in that rate, and so that you're not hit with inflation, let's say, right? With the cost going up and up and up, you get to pay for this particular expense ahead of time. It's not an issue for your children or your loved ones to have to figure out. And so, it's just one less thing for them to consider. All right. I've reached the end. I just want to say in conclusion to have a plan, right? And in that plan, part of that plan is having vision. What does the next 5, 10, 20, 40, 80, 200 years look like for you, your family, your culture, and community? People don't plan to fail, they fail to plan. Are your affairs in order? If so, have you updated them? Financial fitness is similar to regular fitness. Sometimes you just don't do what you're supposed to do. Remember, it's not about you, but rather those people who you love. Get your plan together today. Get it done. No excuses. Do, don't dwell. Our community depends upon it. Make a plan, plan your work, and work your plan. Change comes whether welcome or not. Vision puts you on the purposeful side of change. It makes you intentional about your present. And when combined with execution, it bends the wheel of change. Thank you. I'm out.
That was so informative. I love the pop culture references all up and through the talk because that really helped bring home some of these points. I unfortunately was one of those people who kind of hid my face when it came to asking if I had my estate planning done. But what I got from you, Kyle, is that our legacy is dependent on how we leave, and we have a choice in how we leave, and we can leave ease for our loved ones that are here, or we can leave chaos. So today was a step in the right direction, and I definitely commit to making my estate planning a part of my legacy. I just wanted to quickly talk a little bit more about our theme years. Financial literacy is going on until the end of the year. And then for 2024, our focus is food deserts. What are food deserts? Think about a place where there's a corner store, where there's a fast food restaurant, where there's a liquor store, but there's no farmer's market. There are places where there are things to consume, but not things to give nutrition. Our acronym is GROW, and we want to generate resources and optimize wealth through better nutrition. The other thing about food deserts is it means that there's no agri-science or agricultural economics in communities, which is a larger conversation. That's going to be our focus as we segue out of financial literacy and look at economics on a larger level and look at personal health, diet, and opportunities on the micro level. That is going to be our theme for 2024. Stay tuned for programming, ideas. If you've got anything to contribute when it comes to food deserts, nutrition, especially in urban and ex-urban areas, please get in contact with us. Our link tree is in the chat. That is how you get in contact with us to support, to donate, to volunteer, and to state need. Thank you again so much, Kyle. And I just want to end it up with Ms. Meredith Johnson, our director.
Thank you, thank you, thank you. So we are going to really quickly go through our chat. There were some questions that came up through the chat, and we just want to make sure that we had all of the questions addressed. And some of the questions were addressed in the chat, but just to be clear that we are servicing our public, one of the questions, Kyle, is can you expand on the term living will? And is the living trust comparable to the living will?
Sure. Um, you know, I don't know, these lawyers make these terms up and they're confusing. A living will is different than a living trust. Living will is different than a will. Has nothing to do one with the other. A living will is strictly a written document for end of life decisions. That's it. Doesn't have anything to do about anything else other than that. A living trust is a document that you create while alive that disposes of your assets, um, usually mainly to avoid probate.
Thank you so much. Mr. Jason Green asked, can we refer him to a reputable estate attorney in the Commonwealth of Massachusetts? And Attorney Edmonds has a informational global statement to suggest about referral sources.
Yes. So I actually may be able to do that. You had the good fortune of going to school up there, so we know some folks up there. I'd have to get that information to you. In the interim, what I normally suggest is if you're not in the state of New York, that each state has a bar association, and within that bar association, you normally have a lawyer referral service, and they would be able to refer you to attorneys in the particular area. So this would be trust and estates attorney that would be able to speak to these issues that I talked about today.
Thank you so much. And Stacy Robbins asked us, if the terms outlined in your estate documents remain the same, is it still necessary to update them? And if so, after what period of time? A YouTube attorney suggests that 3 years. Do you agree with that, or are you comfortable commenting on that?
Yeah. So yeah, I think I may have gone past that part, but yeah. Generally, 3 years is good, generally speaking. But if you had some sort of significant development in your life, like if you got married, or you had a loss of a child, or someone who was in your plan that for whatever reason you no longer want them in the plan, these are all reasons to update the documents even within that 3-year period.
Okay, thank you so much. Also, in the state of New York, is it necessary in the state of New York to have a legal back on your estate documents?
No.
Very good. Asked, answer. Again, once we conclude this evening, our community partner, Bloomfield Public Library, will send out a tip sheet by next week. And in that tip sheet, authored by Kyle Edmonds, as he suggested, we may be able to give you some specific referrals related to the tri-state jurisdictional area, but globally, it will be included that without a shadow of a doubt, you can connect with the jurisdictional bar associations in the region that you live. Are there any other questions that have come to your mind as we depart this platform? And our monitor can just answer or open up the line for that to happen.
I did get one chat question sent to me. How many years should you update a will, and does the probate have to be done where the deceased relative lived?
All right, so good question. So yeah, the probate needs to be done in the area where the person resided, right? But it could get a little more complicated. So let's say I'm in New York City and I live in Harlem. then I need to go to 60 Center Street, which is in Manhattan, to probate the will. Now, if you have assets that are outside of the particular state, particularly if it's real property. So let's say, I live in Harlem, but I had property in Bloomfield, then you may also need to do an ancillary probate in Connecticut, in the county as well.
Thank you so much, Attorney Edmonds. Very informative communication today. Just our library monitor just wants to make sure our public has been satisfied and just wants to ensure there are no more questions on the floor.
I see one more in the chat. Do trustees normally receive payment for their services?
It depends on the document and the trustor, the grantor, whether they wish to provide for compensation for them. It is certainly not unusual to do so, but depending on the relationship with the trustee, they may be compensated other ways as a beneficiary. And so, I've had it where it goes either way. And that's the same as an executor for, well, I shouldn't say the same, but an executor for a will, there's actually statutory compensation. The state dictates the amount of compensation one receives. These jobs are not easy. And it's not just a matter of, you should be, feel that someone should be happy with taking care of your affairs. Not at all. These are really tough jobs. You want someone who's competent, who's capable, who's able, who's present. A lot of times, I had a client who, he lived in Harlem and his niece was a lawyer in Michigan. And while you certainly can do it, and it did work out, oftentimes, particularly if we're talking about healthcare agent and power of attorney, it's good to have someone close by, someone who can reach out and touch you, or if it's you to that person to help out, that would definitely be helpful.
Thank you again, Attorney Edmonds. And again, Attorney Edmonds is part of our lecture series for financial freedom, give us liberty and give us debt. Just wanted to reiterate the series for the year. We have had Tara Jackson in February, Madam Money, motivational speaker and subject matter expert in all things money. We had a outstanding guest speaker at our annual banquet, and she was on the line. I'm not quite sure if she's still here. Lisa K. Hines. She's a global leader in investment management, woman of humble public service. We have another guest speaker on the line, Chance McQueen. He will be our noted speaker December 7th for all about things related to purchasing a home one-on-one. That'll be December 7th. Again, we're trying to support our greater community with charitable education and charitable donations. Thank you so much. Thank you for taking the time out of your busy day. We hope that you were enriched. I know I was. Please reach out to us. Oh, yes, sir. Yes, sir.
I'm sorry.
I like the church finger. I like the church finger.
I give you the Omega hook instead. I just, be remiss if I didn't say, I heard what Brother Kyle had to say. And I want folks to know, so I've been doing this for a little while now. And when I first started, I didn't have my stuff in order, or Marcia and I didn't have our stuff in order. And I'm out here telling people they need to get their stuff in order. So I don't want anybody who doesn't have their affairs in order to feel bad. that goes against what we're talking about. You know, it's can be a little overwhelming, but you know, you need to take a step, right? Do, don't dwell. And the main major thing I want to leave you with is that this is not about you, or it's not just about you. You know, if you've experienced the pain of disorder and fighting with family, you know, I mean, you know, this is not something we want to pass along. We want to flip that and be more organized and start talking about these irrevocable trusts to 20, 30, 50 years from now. Talk about the great estates that we have in our family legacy. So, sorry, Meredith.
You're
Oh
muted.
no, oh no,
Do
we
don't
did.
dwell. I like that. Do don't dwell. I'm gonna start saying that to everybody when I miss the stuff I'm supposed to do. Thank you.
No doubt. Just give me the credit, though.
Oh, I got you. I got you. I believe in providence.
Yes, and just in your final closing, it just your presentation and passion and your humility just exemplified what we do as it relates to coming together as family, as Dallas House, for the greater good. Also wanted to shout out one of our original organizational, I believe she might have been the first, if not the second, speaker, Attorney Heather Lawson. She is founder, executive director of Pedal Share charitable organization reigning out of the DMV. And I must say, the list goes on and on. I've never been in such a wonderful contingency of a bunch of legalese. I see a lot of legalese. I see the scales of justice, and there are a lot of attorneys on this phone call. So Kyle, I guess they come out to support you. So thank you so much for all you do. Once again, have a great evening. And as we all know, Dallas House, we are because of you. Have a great week.